Hey, welcome for today's Sunday Rising Tide Foundation lecture, where we're continuing our exploration into a very big and very important set of ideas that was first delivered or introduced last week by Adam. Adam Sedia, he needs no introduction, poet, lawyer, historian, modern jack of all trades and Renaissance man, or aspiring Renaissance man, or however you want to consider yourself. Adam, I think that you have really brought to light a variety of topics a lot of people have taken for granted. I think your poetic work, your work on poetry, has definitely helped you see broader whole top-down compositions and the drama behind the surface appearance of things in a way which gives you a certain edge that I think is lacking in a lot of other lawyers that I've encountered who lack a certain set of instincts. So today, we're going to continue this. The first part of this lecture will be in the description box of this video below for those listening on YouTube, as well as in the chat box for those here listening live. For anybody who has a question, like usual, put your name in the chat box and I'll call upon you in queue once Adam has done the lecture. If you don't want to say your question out loud, just let me know and write it very clearly and concisely, and I'll read it on your behalf for Adam. So with that, Adam, it's all yours.
All right. Let me do a share screen again here.
Oh, I have to give you
a host. Okay, please.
I'm sorry. Yeah, my bad. Make co-host. Okay, try that again.
All right. Go. And give me 1 second to turn this into a presentation here. There we go. Okay, so last week's presentation was about the constitutional framework and the federal courts and their relation to the state courts and the federal system more generally. When you take constitutional law in American law school, probably half the course is devoted just to First Amendment, or I should say about, if you take a 2-semester course, about a quarter of the entire year is devoted entirely to First Amendment jurisprudence, which shows you its centrality to the American idea and to the American system. And I'm going to begin with one of everybody's favorite people, the Duke of Sussex. And as you can see, after he moved to, he called the First Amendment bonkers in an interview with, I think it was Vanity Fair. And I was tempted to title this presentation Bonkers, but I'm not going to. And, you know, that shows by and large the attitude, not just the British, but most of the world and most of the elite of the world, and unfortunately in this country too, and a rising number of our elites view the First Amendment. But it's fundamental, and without it, really, you know, you could say the other rights guaranteed in our Bill of Rights are useless. But it's not a uniquely American thing. It has its roots in the Renaissance and ultimately in Christian humanism. We're going to begin with St. Augustine. He was really the first of the ancient authors to grapple with the topic of freedom of conscience and freedom of expression. And unfortunately, he came down on the side of persecution. But as we say, it's complicated. He recognized that no amount of pressure can force someone to believe something or not. And he tended to view, well, he didn't tend, he viewed in book 13 of his Confessions, persecution as sort of an aid to help someone come to realize the truth if they were to be stubborn. The next real thinker well, I won't say the next, but the next major thinker to grapple the topic was St. Thomas Aquinas, who didn't touch on the topic of persecution really, but he wrote about the free will, and he viewed mankind and the human soul as possessing freedom, which distinguished man from all other creatures and elevated him closest to God. And that freedom was the freedom of conscience to make decisions that were moral or immoral. And that freedom couldn't be taken away. Otherwise, you're just a mere agency of nature. So Aquinas's view of freedom is taken up by Dante, who in Purgatorio has Virgil touch on this view, supposing then that from necessity springs every love that is within you, kindled within yourselves, the power is to restrain it. You know, and he's saying here, mere instinct, if you act on mere instinct or necessity, if you're compelled to an end, it removes an agency from you, and your actions can't be viewed as either moral or immoral. And interestingly enough, I didn't have time to add this slide. When Dante goes into Paradiso in Canto 13, he has St. Thomas Aquinas for his guide. And Aquinas echoes these thoughts. He refers back to Ulysses from the Inferno, talking about bad judgment and cautioning you have this freedom to make choices for good or for ill. And you know, judgment is often impaired by haste. He uses the example of, you know, the thorn, a plant that just has thorns only blooms or grows its rose later. So implicit in judgment is the ability to judge for good or for evil. Building on that foundation, we finally get into the English tradition. St. Thomas More, Sir Thomas More, in his Utopia, which is written in Latin, but he discusses the constitution of this ideal society, this utopia, which comes from the Greek word for no place. And the legendary founder is this King Utopus. And he says in here, he has this Utopus. After he had subdued them, he made a law that every man might be of what religion he pleased, and might endeavor to draw others to it by the force of argument and by amicable and modest ways, but without bitterness against those of other opinions, but that he ought to use no other force but that of persuasion. And then Thomas More goes into why. This Utopus thought the interest of religion of itself required it. He therefore thought it indecent and foolish for any man to threaten and terrify another to make him believe what did not appear to him to be true. And supposing only one religion was really true and the rest false, he imagined that the native force of truth would at last break forth and shine bright. So this is an early iteration of what we call the marketplace of ideas, which in jurisprudence you'll see pop up again and again and again. And Thomas More, he was the Lord Chancellor of England, which is the highest judicial officer. He was essentially what the equivalent of Chief Justice at the time. And you'll notice his title of saint that was conferred on him because he was beheaded for refusing to acknowledge Henry VIII as head of the church. And for that, he's considered a martyr and a saint in the Catholic Church. And Thomas More was a man willing to live and die by his convictions. And this is really the first idea in time in English literature where we have this idea of freedom of thought and expression come up. Now, here's a good time to talk about the English Reformation and the lasting impact it would have on the idea of free speech, particularly in the United States. Whereas on the continent, in Germany, Scandinavia, the Netherlands, ideas preceded action. In other words, Luther, Calvin, they came up with their theology, and then a prince or a king would adopt the Lutheran or the Calvinist theology and just make it the new state religion. In England, it worked in reverse. The action preceded the idea. Henry VIII split from split from Rome, declared himself head of the English church, but it was just so that he could marry a new wife and try to beget a male heir. He didn't address theology at all, and the new Church of England was a mess. In the reign of his minor son and successor, Edward VI, the Henry VIII's theological allies came together and formulated a theology after the Church of England had already been separated. And what you had was kind of a theology by committee, where they took some ideas from Luther, some from Calvin, and retained many of the old Catholic beliefs and amalgamated them into a new sort of theology called Anglicanism. Now, the problem with that is, it satisfied the power elite at the time, but those with strong theological convictions remained unconvinced. You had a large number of what were called recusants, those who adhered to the Catholic faith and refused to adopt the Church of England because they saw it as heretical and the usurpation of papal authority. On the other hand, though, you had what were called dissenters, or I'll get into that later. You had what were called dissenters who thought the new church hadn't gone far enough. Particularly, you had Calvinist believers who didn't like the English church's retention of bishops, and they followed what was called a congregational model, or in Scotland, Presbyterian model, in that the church was run by boards who were chosen from the congregants. And these were called, those who wanted to have the entire English church follow this model were called Puritans, because they wanted to purify the English church. And this broad spectrum of disagreement led to a lot of bloodshed. It led to persecution of a very bloody persecution of the Catholics for over a century, and then another century and a half of political repression. And from the end of the dissenters, or the Puritans, it led to 3 civil wars, plus 2 wars in Scotland, addressing whether the Scottish church would have bishops or a Presbyterian model. So this was definitely an issue on the front burner, and it was forefront in the English consciousness throughout the 16th and 17th centuries. Another philosopher to deal with this topic is Thomas Hobbes and his Leviathan, and he was writing to please his sponsor, King Charles I. So he wrote he came very much on the opposite side. When he's enumerating the powers of the state, or the Leviathan, he says, "It is annexed to the sovereignty to be judge of what opinions and doctrines are averse and what conducing to peace, and consequently on what occasions, how far, and what men are to be trusted withal in speaking to multitudes of people, and who shall examine the doctrines of all books before they are published. For those men that are so remissly governed that they dare take up arms or defend or introduce an opinion are still in war, and their condition not peace, but only a cessation of arms for fear of one another." Thomas Hobbes's whole idea is centered around the idea of the state as maintaining a peace against the natural state of war. And as part of this, Hobbes, of course, obviously views maintaining a correct or an official opinion as part of maintaining this peace. Around the same time, John Milton is writing from the opposite end. His Areopagitica in 1644 is a printed version of a speech he gave opposing an act of parliament that proposed to require all printers to obtain an official license to publish any work. He states, plainly, and this is an off-quoted excerpt, "Give me the liberty to know, to utter, and to argue freely according to conscience above all liberties." It's no coincidence that the amendment later adopted in the new United States appears first. It's adopting the same view that Milton has here, before all other liberties. And there's an interesting argument he makes. He likens treatment of authors in receiving a license, they're being treated like children. When a man writes to the world, he summons up all his reason and deliberation to assist him. He searches, meditates, that's not a typo, that's how it's spelled, is industrious, and likely consults and confers with judicious minds. And then concludes, it cannot be but a dishonor and derogation to the author, to the book, and to the privilege and dignity of learning, to have him, if he be not repulsed and slighted, it must appear in print like a puny with his guardian. In other words, like a child. Milton's view would later be adopted by John Locke in his famous letter concerning toleration. And it should also be noted, Milton's Areopagitica is fiercely anti-Catholic, and I think it kind of undermines a lot of the argument he makes. And at the end, he says, kind of a Marcusean view. We will accept any view except those of who he calls the papists, but I don't think it diminishes his arguments at all in favor of a free press and free expression. Locke's letter concerns mainly religion. The care of souls cannot belong to the civil magistrate because his power consists only in outward force. And then he sort of echoes what St. Augustine said 14 centuries earlier. But penalties are no way capable to produce such belief. It is only light and evidence that can work a change in men's opinions. So he essentially agrees with Augustine's premise, just adopts a different approach to it. Whereas Augustine thought official pressure would lead dissenters to the truth. Locke applies Thomas More's marketplace of ideas. It's only evidence and reason that will work a change in opinion, not outward force. So that brings us to the colonies. Naturally, the colonies being settled from England, from British Isles, took all this baggage with them. And most of the colonies, in fact, owed their existence to the religious turmoil that was happening in the home country. These colonies were founded as refuges. Massachusetts was founded as a colony for Puritans before they overthrew the king and established the Commonwealth in England. New Hampshire was founded by a separate group, and then Connecticut and Rhode Island were both founded by dissenters who were expelled from Massachusetts for heresy, essentially. New York had an established church. It was the Dutch Reformed Church originally, as it was a Dutch colony, and then that was supplanted by the Episcopal Church. Pennsylvania was founded as a settlement for Quakers by William Penn, whose name it bears. Being a Quaker, though, it was one of the earliest colonies to have no established church and to have official toleration, because that was the Quaker view of differing opinions. Maryland, actually, even before Pennsylvania, had a Toleration Act of 1649. Lord Baltimore was given he was made Lord Proprietor, which is essentially owner of the colony, by Charles I. And in fact, the colony is named after his wife, Henrietta Marie of France, who was Catholic. And Maryland was intended to be a refuge for Catholics fleeing persecution at home. But as part of his governance, Lord Baltimore established a Toleration Act, which meant that even though it was a colony for Catholics, Protestants wouldn't be persecuted there. That was abrogated after the 1689 revolution, when the Episcopal Church was made, or the Anglican Church was made the official church in the wake of the William of Orange's seizure of power. And then Virginia and the Carolinas had the established Church of England. When I say, I will use the terms Anglican and Episcopal Church of England interchangeably, because it essentially was the same body until the Revolution, when the American church was known officially as the Episcopal Church. It's called that to distinguish it from the Scottish Church, which was Presbyterian. The Episcopal Church had bishops, episcopus in Latin, and the Scottish Church had elders, or presbyter in Greek. So all of these colonies, especially in New England, had established churches. And in fact, they continued to have established churches until well after the Revolution. Massachusetts was the longest. It kept the Congregational Church as its official church until 1833. And I'll get into later how that squared with the First Amendment. In the years of the Revolution, however, we already have this tradition of pluralism, a recognition that there's a difference in religion among the various colonies. And as part of the efforts to maintain a unified American system, to oppose the British during the war and to keep the country stable after the war, there was a recognition among the colonists and the Americans later that we can't let these religious differences tear us apart or it'll destroy the country. And one of the biggest proponents of this was Thomas Jefferson. As a legislator in Virginia in 1779, he proposed the statute for religious freedom, which was enacted 7 years later. And in the preamble, we see, whereas Almighty God hath created the mind free, and finally, that truth is great and will prevail if left to herself. Again, this marketplace of ideas theory being referenced. And then the General Assembly decrees, no man shall be compelled to frequent or support any religious worship, place, or ministry whatsoever, nor shall be enforced, restrained, molested, or burthened in his body or goods, nor shall otherwise suffer on account of his religious opinions or belief. For its time, that was groundbreaking. And it was certainly the first of any of the colonies of the new 13 states to adopt this view on religion. In 1787, when the convention met, the First Amendment was passed. And again, its biggest proponent was another Virginian, James Madison. And he said, the practice in America must be entitled to much more respect. In every state, probably in the Union, the press has exerted a freedom in canvassing the merits and measures of public men of every description, which is not confined to the strict limits of the common law. Again, there's this recognition of a pre-existing culture, not just with respecting differences in religious opinion, but in recognizing that there's a frankness and freedom of speech that Madison and others wanted to enshrine in the new Constitution. As mentioned in the last presentation, a condition of the Constitution being approved was the inclusion of the Bill of Rights, which was included as amendments. And the very first of these amendments, following Milton, is the guarantees of the rights of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, abridging the freedom of speech or of the press, or of the right of people to peaceably to assemble and to petition the government for redress. So we have 6 rights there. Against the establishment of religion, free exercise of religion, freedom of speech, the press, assembly, and petitioning of the government. And we're sort of going to break these down one by one as we go through and talk about their development. Interestingly enough, prior to the passage of the Civil War amendments, the First Amendment was held only to apply to Congress. Congress states continued to have established churches well into the 19th century. And it's also why there really isn't any federal case law addressing establishment of religion until 10 years after passage of the 14th Amendment. During this period, however, I think it's worthwhile to look at state constitutional provisions. This touching on religion or speech, states were guaranteeing these freedoms in their state constitutions, and I've chosen three, all Midwestern states, but I chose them because the constitutions enacted during that time are still in effect today. We have the Wisconsin and Ohio constitutions, which use nearly identical language. Every person or citizen may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of the right, and no law shall be passed to restrain or abridge the liberty of speech or of the press. And then Montana, its constitution, no law shall be passed restricted to speak, write, or print freely on any subject whatever. So the states were adopting the same view that the federal Congress had, which is why there really wasn't any controversy surrounding these provisions for the first 70, 80 years of the Republic. As mentioned in the last presentation, the 14th Amendment gave rise to the idea of incorporating the restrictions on the federal government against the state governments. And you can, shameless plug, you can look at that presentation for the reasoning why. The cases you see here incorporate all the various rights of the First Amendment against the states, and you'll notice there's nothing before 1925. And again, that's because there really was no issue coming up to the federal courts that would demand action. What happened in 1925? Well, it started earlier in the Wilson administration in the beginning of the Red Scare. And it was state action and there were really federal action too. You had the Palmer raids and other such crackdowns that brought in a new age of censorship and created a new demand for the courts to explore these ideas that really had been uncontroversial for the prior century and a half. So going through the various provisions of the First Amendment, I'm going to begin by, regarding establishment and free exercise, I'm going to begin by quoting Justice Joseph Story, who was a member of the Supreme Court from 1812 to 1814 jurist, and his commentaries on the Constitution are often quoted and considered foundational in the development of American constitutional law. He views the Establishment Clause with some caution. We are not to attribute this prohibition to a national religious establishment, to an indifference to religion in general, and especially to Christianity, but to a dread by the people of the influence of ecclesiastical powers in matters of government. And then he cites the example of England and even the colonists who escaped religious persecution only to engage in it themselves. For example, the Salem witch trials are a prominent example. The right of us, and then again, he hedges himself again. The right of a society or government to interfere in matters of religion will hardly be contested by any persons who believe that piety, religion, and morality are intimately connected with the well-being of the state. And then the real difficulty lies in ascertaining the limits to which government may rightfully go. So for Justice Story, it's not an issue of whether or not there can be some cooperation between church and state. It's a matter of degree. And that's really the question the courts have grappled with in addressing these issues. Another prominent commentary on this is Thomas Jefferson's letter to the Danbury Baptists of 1802 during his presidency, in which he references the infamous wall of separation between church and state. Now, really, the first case to address the First Amendment in a religious context, or just the United States, and it dealt with the prosecution of a Mormon for violating the bigamy laws that were federal at the time. And the defense asserted was freedom of religion, and the Supreme Court upheld the bigamy conviction. And it cited the wall of separation between church and state in Jefferson's letter, which at the time. And then it called the letter almost as an authoritative declaration of the scope and effect of the amendment thus secured. And it concluded that Congress could intrude on religious practices that violated civil laws or laws regarded as necessary by society. And it cited human sacrifice or the now obsolete Hindu practice of sati as examples that where freedom of religion would not trump the law. That later evolved into two schools of thought, the separationists and the accommodationists. The separationists are best represented by Justice Hugo Black, who in his Everson decision of 1947 not only cited Jefferson's letter, but stated that wall must be kept high and impregnable, and we could not approve the slightest breach. The opposite view is Chief Justice Warren Burger in his Waltz versus Tax Commission, which dealt with property tax exemptions to religious institutions. In upholding that, Burger's view was, we will not tolerate either governmentally established religion or government interference with religion. Short of those, there is room for play in the joints of productive of a benevolent neutrality, which will permit religious exercise to exist. So we have wall of separation and benevolent neutrality. That led to somewhat incoherent jurisprudence over the following decades. And I think it's still not entirely resolved. There was a test under the Lemon case which prohibited action as if it was an endorsement of religion. The Supreme Court later abandoned that for what it called a historical understanding of the relationship between church and state. I think the accommodationist view is currently prevailing. We would note the Coach Kennedy decision issued earlier this year, 6-3 decision in which the opinion said, we know of no historically sound understanding of the Establishment Clause that begins to make it necessary for government to be hostile to religion. And it cites the need for mutual respect of differences of religion if we're going to have a pluralistic society. And as of now, that's where the Supreme Court stands on the issue. Restrictions on any religious practice must pass strict scrutiny, which is a high level of review. It will only pass muster if the government action is a necessary means to a compelling government purpose. And here we have from the Sherbert case cited here, government may neither compel affirmation of a repugnant belief nor penalize discriminate individuals or groups because they hold religious views abhorrent, to inhibit the domination of particular religious views. That sums up the attitude the courts have. Now, there's protections for the free exercise of religion. State grants cannot be denied to a religious institution. Of significant note is the ministerial exception to federal employment discrimination laws. In other words, you can't compel female clergy. That opinion comes from 2012, and then the same thing applies to religious schools for lay teachers. And then another significant issue is courts may not lend their power to one or the other side in controversies over religious authority or dogma. And you see this creep up again and again, even in state court litigation, where there's an issue that is really one of church governance or church administration, and it's a lawsuit is brought under the guise of breach of contract or a property dispute, and the courts will examine whether this dispute is really at its core an issue of church governance, and if it is one, they will abstain. They won't render a decision. This is an issue for the church, not for the courts. This is also a pertinent quote from the prominent jurist Learned Hand. The First Amendment gives no one the right to insist that in pursuit of their own interests, others must conform their conduct to his own religious necessities. And then that was a view that was adopted by the Supreme Court, 40 years later. The right of free exercise does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law prescribes or proscribes conduct that his religion prescribes or proscribes. So again, as long as the law is facially neutral and valid, religious belief is not an excuse for non-compliance. What I really want to talk about, though, here is free speech and the press, because this goes to the heart of the exchange of open ideas that was discussed in the early part of this lecture. Justice Story, in his commentaries, says that the First Amendment imports no more than that every man shall have a right to speak without any prior restraint. And that phrase, prior restraint, is key in addressing the validity of legislation in light of the First Amendment. And then the First Amendment, and this is Story's italics, it is in fact designed to guard against those abuses of power by which, in some foreign governments, men are not permitted to speak upon political subjects or to write or publish anything without the express license of the government for that purpose. And then he cautions, a little attention to the history of other countries and other ages will teach us the vast importance of this right. And then he quotes Blackstone. The liberty of the press, properly understood, is laying no previous restraints upon publication. So as we go through American jurisprudence, we'll see this prior restraint as a key factor in determining whether government action is valid or not. And then some theory behind freedom of speech. This is Justice Thurgood Marshall from his 1972 decision, Police Department of Chicago. But above all else, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. To permit the continued building of our politics and culture and to assure self-fulfillment for each individual, our people are guaranteed the right to express any thought free from government censorship. The essence of this forbidden censorship is content control. Any restriction on expressive activity because of its content would completely undercut the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. So that's the second element of a test of the First Amendment test. The first is if there's a prior restraint. The second is the restriction content-based, and very almost never do content-based restrictions pass constitutional muster. And we go back to the marketplace of ideas. Justice Oliver Wendell Holmes, the best test of truth is the power of the thought to get itself accepted in the competition of the market. I'm not sure I would wholeheartedly agree with the way he phrased it. If you read Thomas More or Locke, there's an idea that there is truth, and the truth will prevail against lies, regardless of the forces thrown against it, if only, and it will better shine through if it's allowed freedom to do so. Holmes is more of a well, what's the word I'm looking for? He's more of a relativist, I guess I would say. Truth is determined by success in the marketplace, and if we see the status of culture today, I think we can dispute that point. But that's probably that's one view of the marketplace of ideas. This marketplace of ideas pops up again in the famous case of Cohen versus California, which addressed a man who wore a jacket that said F expletive the draft. If this is going up on YouTube, I don't know if I can say the word. And Justice Harlan, writing for the court, expression is powerful medicine in a society as diverse and populous as ours. It is designed and intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hands of each of us, in the hope that use of such freedom will ultimately produce a more capable citizenry and more perfect polity, and in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests. And I think that's a much better statement of the case than Holmes makes. In Harlan's view, the government isn't capable of making these decisions, and people are rational and best left to their own devices and will make the right choice if only they're given a chance to hear and decide for themselves on the ideas that are presented to them. Now, Cohen is the most famous case in which Cohen is cited is National Socialist Party of America versus the Village of Skokie from 1977. If any of you have watched the movie The Blues Brothers, they kind of parodied this. The American Nazi Party held a march in Skokie, Illinois, which is heavily Jewish, and at the time had a large number of Holocaust survivors living there. And there were all sorts of local, both government and private attempts to ban the march, and the case went through the Illinois courts, and ultimately the United States Supreme Court sided with the Nazis. And under the reasoning of Cohen, said they should have their right to express themselves and be heard, and everyone else has the right to accept or reject what they see there. And that is largely the attitude of the courts through this day. And I think that's one of the shining moments that the United States Supreme Court has had in the First Amendment, in addressing First Amendment issues. Political speech is given the highest protection, and it's recent Supreme Court case says it's subject to the strictest scrutiny, any regulation on political speech. Discussion of public issues and debate on the qualifications of candidates are integral to the operation of the system of government established by our Constitution. The whole idea of self-government and popular sovereignty depends on the ability of individuals to receive, weigh, and make judgments on ideas themselves. That's the whole nature of what a vote essentially is. So this is afforded the widest protection under the Constitution. Other acts that are protected by the First Amendment are expressive conduct. The earliest case from the 30s, it struck down a California law banning the display of red flags, presumably to show communist affiliation. The Tinker case upheld the rights of high school students to wear black armbands to protest the Vietnam War. And then most controversially still is Texas versus Johnson from 1989, which struck down a federal law banning flag burning. In each case, it's not speech, but conduct that was regulated, but the conduct was of a nature that it amounted to an expression of political speech. Similarly, this First Amendment also protects against compelled speech. In 1943, the court ruled that a school could not force its students to recite the Pledge of Allegiance. And then very recently, 4 years ago, the court struck down compelled public sector union dues. In other words, compelled contributions by public employees to their union. And that was unique because it was a government employee, and it was effectively government action compelling the payment. And commercial speech is also protected under the First Amendment, but it's held to be less protected. It's subject to a factored test, and obviously one of the considerations are whether the government regulation is content neutral, number one, and it's designed to safeguard against fraud and misrepresentation and things like that. But it still is protected First Amendment activity. And in fact, if you ever, I don't know how many Americans are in the audience, or if you travel here frequently, you'll see lawyer ads everywhere. That wasn't always the case. I think every state Supreme Court or bar association, whoever was making the rules at the time, prohibited attorney advertisement. It was deemed unprofessional and beneath the profession. Well, around the time of in the 80s, those restrictions were challenged, and the Supreme Court held that yes, the ban on lawyer advertisement what violated the First Amendment, although lawyer advertisement would be subject to the same commercial speech restrictions as other advertisements. There are limitations on free speech. The first one is content neutral, narrowly tailored time, place, and manner restrictions. What this is if you want to hold a demonstration or a protest in the park, you have to get a permit. Those are routinely upheld, but again, time, place, and manner. And as long as it's content neutral and narrowly tailored to the ends of public safety, for example, capacity, safety concerns, things of that sort, those restrictions will be upheld. Imminent lawless action. The Brandenburg case struck down an earlier line of cases that make the Schenck versus US from 1919 that used the more familiar clear and present danger language. That was abrogated in the 1969 case of Brandenburg versus Ohio, where if there's an incitement to imminent lawless action, it can be restricted. However, the court has not addressed that issue ever since the case. So the extent to which that applies remains an open question. Another area that's not protected is a true threat. The Supreme Court said that that's not protected without defining what it was. And again, the court hasn't addressed that since it first became an issue in 1969. Then there's obscenity. Again, this is the seminal case of Roth versus the United States from 1957, which dealt with a pornographic publisher. While it held that obscenity was not protected by the First Amendment, it actually relaxed the standard for what obscenity was. The traditional standard out of English case law was whether it essentially corrupted young minds. That wasn't the exact language used, but that's the point of it. Instead, the Supreme Court adopted community standards of the community in which it occurs. The dominant theme taken as a whole appeals to the prurient interest. And as later case law would elaborate, it lacks serious political, artistic, or news merit. Government speech, it's also a rule that the government can restrict its own speech. So speech by a public official as part of his official duties are not protected. So the Garcetti case dealt with an official who was dismissed for saying things as part of his official duties. But 8 years later, the court held that speech outside of official duties is protected. And that dealt with a government employee who was subpoenaed to give testimony in federal court and said some unflattering things about his superiors and was disciplined for that. And the court ultimately held that that was outside of his official duties and therefore protected, because the government, i.e. his employer, was coming down on him for his individual expression, political speech. Freedom of the press, same rules generally apply, but some more specific rules here. The press has been broadly defined to include every sort of publication which affords a vehicle of information and opinion. That is about as broad as you can get, and obviously that includes the internet. Prior restraints are nearly always rejected. The New York Times case is interesting. Nixon administration sought to prohibit the New York Times from publishing the leaked Pentagon Papers. And ultimately the Supreme Court said, no, it had, even if it disclosed some confidential material, it had worthy news reporting value, and was, they could be held potentially criminally liable afterwards, but the prior restraint beforehand was unconstitutional. Just as with political speech, there's a rejection of content-based regulation. The Miami Herald case addressed a Florida statute that required media to give equal coverage to both major parties in an election. That's been struck down. Taxes exclusively directed at newspapers have been found unconstitutional. Even though they didn't regulate the content, it was held to be an unnecessary burden on the expression that newspapers were in the business of doing. And then content neutral restrictions are permissible, and that's the FCC, for example, licensing radio stations, and that was under the theory of restricted wavelengths, as long as there was no content basis for the restriction, that was permissible. Regarding obscenity, this is one of the most famous offhanded quotes from American case law. A concurrence regarding an obscenity case. I will not attempt to define hardcore pornography, but I know it when I see it. Justice Potter Stewart. I just threw that in there. If you hear that reference, that's what it is. Freedom of assembly and petition. Now, interestingly, this is the oldest right of the bunch. It's specified in the Magna Carta, and the right to petition the king is guaranteed in there. In American jurisprudence, though, it's the least controversial. And as you can see, the cases are comparatively recent. In the first one, it just explains that the rights secured by assembly and petitioning are essentially the same ones protected by freedom of speech in the press, the right to express ideas, hopes, and concerns. And then a component of this is the right of access to the courts. It applies to the judiciary as much as to the legislature. Now, the First Amendment cuts into other areas that of the common law that have been around for centuries, and redrew the landscape in a couple of ways. The first one is defamation suits, and anyone who's familiar with British law knows that it's much easier to win a defamation suit there than here. This issue went to the United States Supreme Court in 1964. Filed by an Alabama official who claimed that the statements made by the New York Times regarding his treatment of civil rights protesters was defamatory. And the court tackled it, and it at first quoted learned hand that the First Amendment presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and will always be folly, but we have staked upon it our all. Again, the marketplace of ideas theory at work. The court tackling with this reached the conclusion that the First Amendment requires a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice, i.e. that knowledge that was false or with reckless disregard of or whether it was false or not. So it can't just be negligent, which was the traditional rule. It had to be done with actual malice, which requires proving a mindset, which is extraordinarily difficult. And there are two other limitations. The official has to prove that the defamatory statement was about him individually and not about government policy generally. And then it also shifted the burden. Normally, truth is what we call an affirmative defense to a defamation suit. In other words, even if what I said was defamatory, it was true, and therefore there's no recovery. Well, affirmative defenses have to be proven by the defendant. New York Times versus Sullivan switched that burden. The official has to prove the statement was false. Some states have adopted, now this standard does not apply to private individuals, but this is a bare minimum. Some states, I know Indiana for sure is one of them, apply the actual malice standard even to private defamation suits or defamation suits against private individuals. So in many jurisdictions, defamation is extraordinarily difficult, and you just don't see any amount of defamation suits like you do in Britain or in other Commonwealth countries. The other area, and I think this is fascinating that the First Amendment touches on, is copyright. The copyright statutes themselves are clear that in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied. So in other words, copyright protects the work, not the ideas behind the work. And this is called the idea expression dichotomy. And in addressing this, the US Supreme Court stated that this strikes a definitional balance between the First Amendment and the Copyright Act by permitting free communication of facts while still protecting an author's expression. No author may copyright his ideas or the facts he narrates. So in applying this, we have the concept of fair use. And Joseph's story, as I mentioned in the last presentation, was instrumental in the development of early intellectual property law in the United States. And in his decision sitting as circuit judge in Massachusetts, a reviewer may fairly, this is a case that dealt with, there was a 4-volume biography of George Washington published, and then a later publisher republished 2 of the volumes under his own name, citing it as a review. But in the suit for copyright infringement, story obviously found for the plaintiff. A reviewer may fairly cite largely from the original work if his design be really and truly to use the passages for the purpose of fair and reasonable criticism. On the other hand, it is clear that if he thus cites the most important parts of the work with a view not to criticize, but to supersede the use of the original work and substitute the review for it, such a use will be deemed in law piracy. Piracy, his words. What do pirates do? They hijack ships and use them for their own purposes. That's why you see piracy as a term used for infringement or of copyrights or patents. And then he cites this factored test, which was later adopted by Congress in the 1976 Copyright Act as the 4 factors to judge whether use is fair or not. And the purposes that qualify as fair use are criticism, comment, news reporting, teaching, scholarship, or research. Copies made of copyrighted works for that is not infringement. And then there's this 4-factor test: the purpose and character of the use, the nature of the work, the amount and substantiality of the portion used, and the effect upon the market. And whenever there's an infringement issue, those 4 factors are weighed. And even though the First Amendment isn't referenced, implicitly, the whole concept of fair use and fair use purposes have their roots in the First Amendment. And this was acknowledged in Eldred versus Ashcroft. That's an interesting case. Originally, copyright protection was for a term of the life of the author plus 50 years. And when Sonny Bono served in Congress from California, he spearheaded an expansion of that protection to life plus 70 years, and it passed, and that's currently the status. Well, many companies who were publishing works that had been in the public domain now saw those works yanked from the public domain for another 20 years. So they challenged the law as unconstitutional, and the law was upheld. And Justice Ruth Bader Ginsburg, writing for the court, said the copyright clause and the First Amendment were adopted close in time. This proximity indicates that, in the framers' view, copyright's limited monopolies are compatible with free speech principles. Indeed, copyright's purpose is to promote the creation and publication of free expression. The fair use defense allows the public to use not only facts and ideas contained in a copyrighted work, but also expression itself in certain circumstances. The fair use defense affords considerable latitude for scholarship and comment. And thus, the existence of fair use being grounded in the First Amendment meant that the extension of the copyright term didn't infringe on any constitutional protections. And I also want to cite this because there's this impression that Justice Ginsburg was this, raging. That's actually not the case at all. She's been very influential in the area of intellectual property, and she is quite conservative in her views on that, which, surprised me when I started taking law school courses, and certainly gave me a more nuanced view of her and her Jewish, Freudian slip there, jurisprudence. So that, and then, yes, also the issue of parody. Parody is protected, and It's no surprise there, but there's an interesting case that arose out of a parody done of a rap song, I think by a country musician. The case was out of Nashville. Parody needs to mimic an original to make its point, and so has some claim to use the creation of its victim's imagination. Hence, parody is protected fair use based on the First Amendment. That's where I'm concluding. That's all I have for you today. I just about hit the 1 hour mark too, so that was.
Yeah, that was great. And again, I just really appreciate your capacity to go both into the specifics, into the minutia, but then to bounce back to the whole and then back to the minutia in a very organic way. It's really great. And I mean, there's a lot of questions I have in my mind. I'm going to withhold for the moment. I know Jerry has the first question, and then I might throw in a question for myself at some point too. So Jerry, go for it.
Okay, thanks very much, Adam. It's very enlightening to learn about the First Amendment rights of Americans, since we in Canada, I don't think we have them. Although I have been told we still have two rights in Canada. We have the right to an attorney and the right to remain silent. But I had a question on free speech, because I remember when Ray McGovern was on, Rising Tide Talking, he was talking about this. There's a disinformation center in Ukraine, and if they don't like what you're saying, they put you on this list and say it's enemy propaganda. And they had put Ray McGovern on this list. And there's other people who've also been put on there. I think Scott Ritter was talking about it too. And the point that they were making was that it was the US government which was supplying funds to Ukraine so they could run this disinformation center. Now, you know more about law than I do, but this is hypothetical. Would they actually have a case that since the US government is supplying the funds for this thing, that it's restricting their freedom of speech in America?
That's an interesting scenario. So if it actually had an effect that was felt in the United States, I think you could potentially make that argument, because it's still United States government action that has an effect on the individual, even if it's by indirect means. I'm not sure what form that effect would take, but if there were some action, this could get into a real complicated area, because now you're dealing with federal statutes and things like that. If we're dealing something outside of the internet, or treating what do you call platforms as a forum rather than a publication, and that whole issue, which is a can of worms unto itself. It's something I would certainly like to look at if someone could come to me and show harm in the United States. I'll phrase it that way.
Okay, thanks very much, Al.
I'm sorry I couldn't give you something more direct, but it would depend on what sort of harm they suffered in the United States. If they're restricted in the Ukraine, the government can always say, oh, well, that's a different government actor in another country, and they'd probably be right. But if there was some tangible effect in the United States, I think that argument could be made.
Stephen, go for it.
Okay, Adam, thanks. And since we're in October baseball season, I'll say that you hit one out of the park for the second lecture in a row. Thank you very much.
Thank you.
I've got a couple of thoughts, questions for you. The first one is related to the marketplace of ideas, legal doctrine, for lack of a better term. If you look at the complaints in recent years that US social media giants are suppressing free speech, and especially conservative voice free speech, and you add to that the suspicion that these entities are actually fronts for nefarious activity within the US defense intelligence complex, if I can call it that, is there a case to be made in US constitutional law against the suppression of conservative voices and free speech by social media giants under bogus claims of disinformation or false information or spreading COVID untruths, whatever you want to call it? Is there avenue for conservatives in the US to attack the social media giants via this marketplace of ideas doctrine?
Potentially, it would have to depend on the degree and the type of interference or direction, rather, by the government in these social media companies. In other words, if they were just a mere instrumentality of government agencies or directives, potentially yes. But again, there's the people running these things aren't stupid in a bad way. They're a lot of them are trained in the law. They're very good at masking their action, and it would require a lot of deep digging and a lot of discovery and a lot of getting past official stonewalling to come at it. And it's frustrating because it's one of those things, we all know what's going on. It's obvious, I think, to anyone with a brain in their head, but getting the facts to prove it, that's the difficult part. And along those lines, I think with the crackdowns on the January 6th demonstrators, you may see some more development in the case law as far as what immediate threats and incitement are, because that whole case law withered away 60 years ago, and maybe we'll get a refresher and a revitalization of that jurisprudence. Give me 1 second. Apologize for that, my kids kind of took over here.
Stephen, did you say you had a second follow-up question, or?
I do, and it kind of relates to the in the realm of the New York Times versus Sullivan, and your comment that it's far easier to win a defamation case under British law. And I thought I'd just relate a Canadian case here, where a divorced father discovered that there's appears to be a covert program within Ontario's child protection apparatus of maliciously interfering in cases of divorce under fraudulent child protection cover of law, if you will, to create a status quo and primary caregiver divorce advantage for mothers. So this father went in and found in his case, and that happened to him, he alleged that the feminist judge was colluding with the child protection social workers, but he found that the whole child protection action was made in explicit contradiction to the actual child protection regulations at the time. And therefore he felt that losing custody of his kids actually hit the crimes of abduction under the criminal code in Canada in 2 cases. And when he complained to the Ontario Judicial Council, they wrote back and said that he complained of abduction, and they put the word in quotes as opposed to the actual criminal allegation that he'd made. When he went to write a book and expose this and ran this by a Canadian defamation lawyer, he was shocked to discover that in Canada, the burden of proof in defamation cases rests on the person making the statement. So the father, who was certain that a crime had been committed by a judge in terms of malicious and manifestly unlawful child protection action, was placed in a situation where if he actually named the judge in his book, he would be liable for defamation lawsuit, and he would have to prove that to a court system and a judicial council that had already played ostrich and basically ignored his things. So not that you necessarily need to comment, but whatever problems may exist within the American system and the contentious nature of free speech, it is wholly superior to what exists in Canada, where it's set up to suppress you if you're trying to expose government criminal malfeasance.
Do you have the name of that case or the book? Did the book actually get to print?
Yeah, I believe it was self-published. I'll work via Matt to give you my email address. So I'll get you that information afterwards, but it's very interesting and kind of sad too. And I guess my last question gets into the IP law and Joseph's story and all that sort of stuff. And this kind of comes at it from the broader CanadianPatriot.org and Rising Tides. I understand that there's a British company with very, I'll say, City of London establishment type ties called Serco that has a major contract with the US Trade and Patent Office in that they do all the vetting of patent applications. I don't know to what extent it gets into copyright as well, but it seems to me that from a US security point of view, you're allowing a foreign entity to vet all your patent applications to see what was be developed. You can stonewall things. You can potentially open up for nefarious intelligence action. Does that pass muster with the First Amendment in the U.S.?
Yeah. So let me kind of take a big picture view of this. So copyright protects creative work. So there's really no vetting process for it. And in fact, you don't even have to register a copyright for it to be valid. In other words, let's say I compose a symphony and someone plagiarizes it. I don't have to have registered it to sue the person. However, when I sue them, I have to prove that it's an original work and prove the validity of the copyright. If I register it, I come to court with that burden of the presumption, and it's on the defendant to prove that my copyright is invalid or that the work is already in the public domain or something like that. Patents work a little differently. Patents are only issued for new ideas. So if there's what we call prior art that teaches the same invention that's described in the patent is invalid. So part of the vetting process is to find out what has been disclosed, and it doesn't have to be patents. It can be any sort of any scientific or other literature. There's a case from the 90s, I think, where a single copy of a graduate thesis in a library in Germany that predated the filing of the patent was used to invalidate the patent. So it's a very high burden to prove that your invention is new to obtain a patent. So the USPTO's pooling its resources internationally to find prior art doesn't really send up a red flag to me. As long as it's doing what it's supposed to do, let's put that major caveat on it. Because what it's theoretically doing is looking for stuff that's already publicly accessible. It's essentially just expanding its searching capabilities to find what's out there to determine whether an application actually states something new for a patent or not. Now, what else they're sharing and anything that is not publicly accessible, maybe there's something there, but for its stated purposes, that doesn't send any red flags up to me.
Okay, thank you.
Sure.
I have two questions. I'm gonna throw one question in before letting it over to Satomi. One question, it deals with what you mentioned regarding the Pentagon Papers. The other one is a little bit more broad, and I'm going to go for the more broad one, I guess, for now. In regards to the expiration date of what is it? Copyright protections involve the works of somebody throughout the course of their life and then 70 years afterwards, right? Okay. This is specifically American. Are there similar, first part of the question, are there similar types of conditions on like European, British copyright laws as well, or is that specifically American?
That is specifically American. I know and I couldn't tell you how many years, but I know British and I think European copyright is defined in terms of life plus a stated amount of years.
Okay.
And now there's other nuances too, like for example, anything in America published before 1924 is automatically public domain. And if the work is made for hire, in other words, you're either contracted or you're an employee and you do it, the protection is 99 years from the date of creation. But I'm pretty sure, I think it's life plus 50 still in Britain, but don't quote me on that.
Okay, so here's my main question then would be, recently the British Crown, I think it was about a year and a half ago or 2 years ago, recently announced, that they would make public a new batch of Da Vinci works from the folios that are under control of the Crown. And, something like 90% of the different Da Vinci pieces have a little Crown stamp at the bottom, as if they're somehow property of the Crown as an institution. And I'm just wondering, like, Da Vinci died a very long time ago, I think 1514 or something.
Okay, all right. I know where, yeah.
Right. How's this work? How does that work? Like, why are these not?
Well, yeah, I mean, there was it's Britain. There doesn't have to be general applicability. So yeah, the Crown is an exception for that. Another one, I don't know if you know this or not, is the King James Bible. That is still under copyright and it's owned by the British Crown. Whenever you see authorized version, that means that it's under copyright of the British Crown, and that's the official licensed. And I don't know the details of this, but the Crown is not subject to those same restrictions that private copyright holders are.
Oh, that's interesting. Okay, I figured as much, but that's yeah, shady. Okay, thank you. Satomi, you can go through your question.
Oh, thank you. Well, thank you for that interesting presentation, because you presented it so the examples you gave are so good that, I mean, gosh, there's like anything goes. Like, you can go either way. The interpretation it really depends on the judge in a lot of the cases. And it just kind of reminds me what happened in the Old Testament, where a law just became so many rules, and just the 10 commandments. From that came all this volumes of the Talmud, what they call, and so the New Testament had to filter through that. So my question is, sometimes, like treason, like I see so much treasonous acts that are happening, because we can't get behind the intention, the conscience and the intention, right? We have to just go by the letter. Sometimes I think, like, and maybe this might be another discussion, the military tribunals might be some answer to so many of the stuff that's happening. I don't know what you think.
Well, you bring up a good point, and this should have been, I considered making it part of last week's presentation, but treason in the Constitution has a very limited definition. It's specifically defined in Article 3. It consists of offering aid and comfort to the enemy in time of war, and nothing else. And that provision was designed to prevent, speech, political speech from being regarded, or religious observance from being regarded as treason. Because remember, in Elizabethan, in Elizabethan and later Stuart England, being a Catholic priest was considered treason because you weren't acknowledging the monarch as head of the church, and you were subject to the punishment for treason, which was being drawn and quartered. The limited definition was designed to prevent abuses like that from happening. However, the flip side of it is when you have actions going on by people in government that I think in many cases should be regarded as treasonous, it doesn't fit that very restricted definition. So again, what's designed to be a shield is being used as a sword by bad actors.
Oh, thank you. Yeah. So I think we should do one on the military tribunals. Like that's another, isn't that another kind of a way to deal with certain things that can't be dealt with by the Supreme Courts and the.
Well, yeah, I mean, military tribunals are only used for military discipline. In other words, if you're a civilian, you're not subject to the jurisdiction of a military tribunal. So if you're a soldier and you sell confidential information, yeah, that's a court martial, that's a military tribunal. And again, there's a review process. There's the Court of Appeals for the Armed Services, and that answers to the Supreme Court, just like all the civilian courts. So even the military justice is subject to civilian review in the Supreme Court.
Well, so like when a coup happens, there's nothing.
Well, if a coup happens, the Constitution's out the window.
I know, but how do you deal with things like that then? This is sort of something we have to have a discussion about.
Yeah, I mean, it goes back to what I talked about last week. Our Constitution is designed for a moral and religious people, is wholly unsuited to any other. And what Plato says too, if you don't, a constitution is only as good as the people that make up its society. And if the people running things or the people at large are morally depraved, a constitution isn't going to be a safeguard.
So it's almost like, you have to be in a state of war. I remember Ezra Pound was, during the war, he was brought back on treason and almost would have, I don't know what, but he was just saved because of his, his contribution to art.
Yeah, well, I don't think he was ever formally tried. He was committed to a mental, and again, that's another abuse of power that happens frequently. He was committed to a mental institution. They just said, "Oh, you're crazy," and they forced him to be hospitalized. Just like Castro, put his political enemies into electrotherapy. That's another method of subverting justice, is you don't try them, you just say they're crazy and lock them up.
Yeah.
Okay,
Thanks, Tommy. Shannon,
Actually,
yeah, go for it.
yeah. Military tribunals have been going on for some time now at Gitmo and in Washington, D.C. and in the White House. I mean, this has been known for some time. This has been going on. That's a big part of what the lockdowns were about. You'll notice that Hollywood has gotten very quiet in the last couple of years. A lot of clones and doubles are being used in CGI for a lot of the elite. Military tribunals are being used on civilians. It does cover it. We are at war, and this is, they are going against the cabal. They're using not only the I think it's the RICO, which is to take down mafias, where everybody is covered, whether you're named in the suit or not. And then also military tribunals. Several people have been able to come forward, and they have actually gone and testified.
Are you saying civilians, Shannon, or
Yes,
what
yes,
are being
yes.
prosecuted by? Okay,
Child
well,
trafficking.
let's let Adam.
Child trafficking and all this other stuff.
Okay, all right. Well, I don't
Yeah.
know. Adam, do you
They're
want to
about to
give
become
a quick thought to that?
Yeah, I just say when I'm talking about the limited use of military tribunals, I'm talking about how they're designed to work and how they're set up. I'm not speaking to actual abuses of power that are going on and that we know are going on. So put a big asterisk next to what I say with that regard.
Thank you.
Okay.
Monty, I know you have a thought that you wrote out in the chat box. I don't really know how to frame that as a question. So Monty, I don't know if you're still there. Yeah, you are there. Do you want to frame that as an oral question for Adam? Going once, going twice. Oh,
All right. Yes, Adam, I ran across this in a podcast just a couple of days ago. I understand that King Charles is introduced an actual seal, a British seal called terra carta seal, for companies that meet his criteria for protecting the rights of nature and plants. Have you heard about that, or could you comment on it?
No, it doesn't surprise me in the least. I haven't been following the new monarch's actions, I'll confess, but it doesn't surprise me. Is there any penalty for not having it, or is it my from what it sounds like, it's, you know, how Harrods or Ahmad tea, you know, if they were official caterers to the royal household, they got to use the seal that distinguished them. It sounds like the same thing, but, you know, just for meeting their standards for whatever they define as environmentally friendly. Is that sort of what it is?
Yeah, I think if they meet certain criteria, they get this seal and it's awarded, and presumably it has something of a Nazi flavor to it, and that Hitler did, in other words, granting certain recognition of corporations or so forth that meet criteria that they standards they adhere to. I think this just happened in 2021, where this is came out, and even Cummins Diesel and PepsiCo are now being awarded this seal. They've actually, you can Google and see this emblem with a little crown on top and flowers around it and so forth. But it just seemed like a, you know, they were trying to take off on the Magna Carta.
Oh, well,
And so-
yeah, there's that's a whole, or you can say ESG is just the whole thing writ large, except that has like real world consequences. You know, you can't qualify for a loan unless you meet the criteria of an NGO. And again, that's another thing to caution about. Everything I've talked about, the First Amendment restricts government. It does not restrict private enterprise. So and then that's the danger of companies getting too big and working in tandem. You have organizations like the World Economic Forum and all of these that they come out with a list of standards, and then the big players in private business all adopt them uniformly. That's outside the First Amendment, and there's no restriction on that, and that could actually end up restricting an individual right just as much as any government action could. And I think that's where the real danger in the years ahead is going to come from.
Thank you.
I've got a question, I guess, in regards to the ability of sovereign nation states to rein in the type of abuse. And I mean, you know, you look at the amount of ownership under the majority of the corporate media today, and you compare it to maybe even 40 years ago when there was something like 50 different owners of various news and televised print media agencies. Today, it's something like, I think you could count them on one hand. So the concentration of power into a private class that's very interconnected with different other aspects of intelligence, banking, different functions of the supranational institutions above governments are very, very large, very broad, and very, very much working together, as you alluded to, the Davos clique. So the sovereign nation state, obviously, no wonder they want to dismantle and destroy it, because it does give the people an immense amount of political and legal power to do things in defense of the people. Today, what sort of ability would there be, let's say, to break up some of these big tech monopolies, or other food monopolies, or other things like that that need to be bounded by law instead of controlling the law? Is there anything like that you can think of?
The framework for doing that is already there, and it's been in place for over a century. The United States has the Sherman Antitrust Act, which was passed in 1890, and that's designed to break up monopolies, prevent anti-competitive behavior is what is restricted. And Theodore Roosevelt was quite enthusiastic about applying that. In the years since, though, it's hardly ever applied. I think, you know, Bell Telephone was a major one, you know, afterwards, but they may have even brought one against Microsoft, and it probably settled, but it's not used as often as it should be. And in many cases, there's statutory exceptions to the Antitrust Act. The base sports leagues are one example. They're in that case, it's deemed that, you know, in order to have everyone playing by the same rules and to have a sport, it's necessary that there be some sort of monopoly in it. But the tools are there. It's just nobody's using them because, you know, you oftentimes the people who have the power to bring this and bring the enforcement are in bed with, or at least agree with, the people they should be going after. You know, it's in, you know, will an election change that? We'll see, but you know, it hasn't so far.
Can I just quickly ask, do you think money has, because, you know, like a small person or a small corporation going up against these, they have all the money. Would that be a factor?
Well, that's always a huge factor, but like antitrust suits are, that has to be brought by, you know, that's a government action. It's a criminal act, it's a regulatory act, so it has to come from the government. I mean, you as an individual could sue under civil RICO theoretically, but you know, you'd be up against behemoth corporations with well-funded lawyers, and you know, first of all, good luck finding a lawyer willing to, you know, stick his neck out and take the case. You know, guilty as charged on several of those. You know, you're underfunded and you can't face up, and the odds of getting the judiciary, which is the government, to side against the government is slim. So the action's going to have to be effective. It'll have to come from someone who can hit just as heavy as the entities that should be regulated.
The other, I guess the last question I personally have, and then we'll have time maybe for one more from the audience if anybody has something pressing, is in regards to the Pentagon Papers. You said something I didn't know, which was that it was decided that the content circulated, I guess, or released by Daniel Ellsberg at that time was newsworthy and could not be censored. Though the surprising thing is that you said that it did reserve the right to prosecute. I suppose you're referring to Ellsberg, not the media agencies themselves after the fact, is what you were saying?
Yeah, correct. Yeah, it would have been Ellsberg and anyone else involved with the leak. Again, it's what we call dicta. It's not an essential part of the holding, but what the Pentagon Papers case addressed was the issue of prior restraint. And in First Amendment jurisprudence, you can be civilly or criminally liable for an action you take, but the government can't restrict you from engaging in the speech beforehand. And that was the point that the New York Times case made.
And nobody did attempt afterwards to prosecute Ellsberg, did they? Or was
I haven't looked into that. I'm not aware of it, but it doesn't.
So the reason why I just want to be clear on that, for the question on Julian Assange right now, I was wondering, in your view, since the Ellsberg situation definitely creates a very strong legal precedent for the defense of making public newsworthy material, even if it was, you know, not intended for public consumption by governments. Do you think, what is the current, again, I have a general idea, but what I wanted your basic opinion. What are the chances that Assange, if he is extradited to the United States, how could they possibly get him as a foreign citizen who did something which is similar to what Ellsberg did, which was then basically, you know, recognized as being, I guess, legal overall? Is there actually a chance that like John Bolton says, he intends to see Assange in prison for 170 years? Do they actually have something on Assange, or is it, are his chances actually better than we think?
Well, you know, I'll preface this answer with there's a it's a Twitter account, and I can't remember the gentleman's name. He's a former federal prosecutor, and he said he would tweet out one federal crime a day. And I heard an interview with him. He was like 3.5 years into the process and still hadn't gone through the entire list. So I'm sure there is a federal crime on the books that they can get him for, in theory, regarding classified information and whatnot. How it's applied and what his, his defense will obviously be, First Amendment. How that'll work with the judiciary. I mean, you do have that precedent that would be favorable to him, but we'll see how it applies. And a lot of this is heavily fact dependent too. I mean, you have a lot of defenses that look good on paper, but then when you get into the facts, not so much. So I don't want to make any predictions, but it will, I'll just say it'll be interesting to see how it plays out.
Thank you. All right, everyone. So I think we're rounding out our Sunday afternoon here. Oh, got. All right, I have been derailed from my concluding remarks. Leon had a quick thought he wanted to share briefly, or question.
Thank you, Matthew, and sorry for derailing it here. Thank you, Adam, very much for that. So I'm from the Netherlands, so I'm looking a little bit also from the legal situation there, and we do have free speech in our constitution in the Netherlands. But I think what we see, I wanted to come back to that misinformation element, which is, I guess, the major threat right now, because I think what you see politically, there's more and more this kind of standard being introduced in the rhetoric that yes, there's free speech, you can have free thought, and so. However, provided that it doesn't contain misinformation, this is kind of a standard that you can, in the political discourse, you feel that a little bit coming, and of course, this is an erroneous perception of reality, I guess, because it assumes that any kind of statement is linearly related to something which is objectively true, and there's only one version of what is objectively true, and so. But and also, of course, ethically, it's wrong as well. We know that. But I wonder about how you see it legally, because if recently there was this speech of the Prime Minister of New Zealand, I think, in the UN, where she was saying, "Oh, we all need to do something about misinformation." And she gave the example like, what if people, through misinformation, they don't believe in climate change, and that will affect our effectiveness of how to do that. So I think what they're looking, where this is going is that you can say, yeah, free speech, all fine, but misinformation, which is kind of threatening something which is in the public interest or a threat to the public interest, like climate change and in sense of COVID. How do you see that? If you would have to defend that as a lawyer, let's say, do you see a legal space in that, in the realm of free speech? Thank you.
Oh, sure. No, I think there's a definite push for that. In fact, our current administration attempted to create its own misinformation committee or bureau, whatever they called it, with that crazy lady who parodied Mary Poppins and all that. That was nixed as soon as it became public. To answer your question, though, that would not fly under the current jurisprudence in the United States. I mean, there would have to be a complete reversal of the way free speech decisions have gone for the last 100 years for the idea of misinformation to be used as a reason to restrict speech. And I say that because the courts are very much married to this marketplace of ideas theory, in that an idea might be bad or it might be false, but ultimately it's up to the individuals to make that decision. Now, that doesn't mean if we get a few bad appointments to the Supreme Court that could be reversed. But as things stand and with the court we have now, I see the likelihood of that misinformation trend going nowhere, at least with the judiciary.
Okay, that's good news. Thank you.
Fingers crossed.
Yeah, I think overall what hovers across all these presentations you've given and the whole legal discourse is this question of what is the nature of human beings, and are human beings endowed, as the founding fathers believed, as Thomas More believed, Augustine, Plato believed, as creatures made in the image of God, with a soul that has certain common attributes to the creator that created said works, being us as included amongst those works of creation themselves. And if so, then there's certain ideas of what rights are that follow from that idea, that very noble idea of human beings, which have certain universal traits that are eternal, that are transcendental. And if you don't believe that, then the idea of rights really just seems to come from an idea of whoever has the strength to impose their view and give you or take away whatever types of liberties they deem fit or expedient at a certain given moment in time or another, which is a very disgusting, but albeit maybe too popular view of what rights are today, where people have been very their idea of their having even a soul is not, it's not a very popular thing for young people, especially, to even have a strong sense that they even have a soul, that they're not just this nihilistic, ball of chemical electromagnetic flesh with urges and impulses. So if you don't think that human beings are fundamentally endowed by universal qualities of creative reason, conscience, if those are not there, then you might not really want to defend those principles of the Constitution, or you might see them as just outdated, in need of being superseded by something more relevant to our modern times, more flexible, and maybe blob-like, that would be more expedient for a governing class to control, instead of what you've been going through, which is something much more beautiful. And again, the idea of the marketplace of ideas and the different views of it, I think, is also very interesting. How you have just the word itself gets kind of abused, and the fact that you don't have everybody having the same thoughts. Like when Thomas More, I don't think he used the word marketplace of ideas, but you certainly see the idea of the belief that if you let ideas free, the truth will defend itself, because he believes we have reason, and with discourse, where people could put their thoughts on display in defense of the truth, that the truth would win. It's different from people like Felix Frankfurter or eugenicist Oliver Wendell Holmes, who had a more Darwinian idea of the right of the ideas that will win over the weakest ideas, simply the most powerful ideas. And it doesn't necessarily mean the most truthful ideas. It just means like the Darwinian believes, right? It's the powerful will destroy the weak, even if the weak are more true. It doesn't really matter, does it? But so it's fun to just get that topography in the domain of ideas, the way you outlined it. I think it's really rich. If you ever want to write something on this, by the way, I'd be more than happy to publish something just on that alone. That would be rich.
Oh, I'll put something together. I'd be happy to.
That'd be cool. Well, everyone, thank you for showing up, and thank you so much, Adam, for going through this today. Really, really excited to get this out there, and we'll see everyone probably next Sunday, same time as always.
Thank you.
Bye.
All right.
Thank you.
Right.
Okay, thanks very much.
And John, yes, to answer your question.
Bye now.
Bye.
Bye, everybody.
Yes.